Hello, everyone. This is Tom Fox back again for another episode of the award winning Everything Compliance. Today we have the quartet of Jay Rosen, Jonathan Armstrong, Matt Kelly, and Karen Woody. So, Mr. Armstrong, taking the pole position as usual, what are you thinking about today?
Well, thanks very much, Tom. I think this week I've been directed as to what to speak to after our discussion last time around about what are the SFO up to and what's the SFO's new director up to. So for those of you who didn't follow the news, we had a new SFO director from September. He's called Nick Grave. He's a former policeman. He was the chief constable of Surrey Police, and he obviously took over the Serious Fraud Office at a time of some displacement, let's just say, putting it mildly. They've obviously had issues with the with ENRC, with Unaoil, with their odd employment practices. The list could go on, and obviously we've talked about some of those issues on these podcasts in the past. And he seems to have hit the ground running. Even about 3 hours ago, he announced the opening of another investigation into buy-to-let cars, which seems to have involved two directors being charged after some dawn raids. And he seems to be, I suppose, the early flavour of his tenure has been what you might call good old proper coppering. You know, he is a former policeman, and a lot of the activity does seem to be, similar to old-fashioned policing. He's also launched an investigation into safe hands plans, the way in which financial plans were sold for things like funerals. He has secured the conviction of David Black. This is obviously a legacy prosecution, but I suppose he gets the credit for that, just as previous directors have got the debit for when things have gone wrong on their watch. So he secured these convictions in December. It was the second prosecution for the same individual. David Black, as well as being a fraudster, was somebody who frequently changed his name. Spoiler alert. We'll look at a similar person in my shout out at the end. So he's also known as David Hardy, David Diaz, David Stark, not David Bowie, unfortunately, but a serial fraudster. He's done a dawn raid just before the holidays on AOG Technics. This is a long-running investigation into airlines, and in particular the connection between bribery, or the alleged connection between bribery and airline safety. So the allegations seem to be that the difference, if you like, that was paid for bribes was made up by reducing the quality of air parts, and that led to safety concerns from both the UK and the US authorities. Obviously, to state what is plain, you sort of don't want to skimp on the parts for aero engines and have substitute parts there to fund a bribe scheme. And I stress that they're allegations, they're not proven, although planes in various places have been grounded as part of this investigation. He's also secured confiscation orders in the Bali steel collapse. On two occasions now, he seems to have confiscated golf memberships, which seems to be an interesting enforcement strategy. What the SFO does with a golf or a country club membership once it's confiscated it, I don't know, unless they auction it off. He's been looking again, almost old-fashioned coppering at Swiss bank accounts, at offshore trusts. He's secured a conviction of a lawyer for tipping a client off about an SFO investigation. And these things called Section 2 notices that we've talked about before, that have been used against US corporations when executives land on UK soil, you demand information from them. And then perhaps more interestingly than all of those, he's launched an investigation into Axiom Ince. So Axiom Ince are, if you like, the successor legal practice to Ince & Co., a well-known largish UK law firm founded in 1866, well known as one of the preeminent shipping firms in the UK previously. He has led dawn raids on 9 addresses as part of that investigation, 7 arrests. The allegation concerns £66 million in clients' money going astray. There's all sorts of subsidiary, sordid but semi-interesting allegations involving seedy nightclubs and bottles of very expensive champagne. But the interesting thing, I think, here is that he mobilized 80 SFO staff together with support from the police to get up early in the morning. So that to me suggests that some of the allegations about poor morale, of not being able to mobilize people when required, we might have seen an end to those as well. So as I've said, it's early days really, but there are a number of hallmarks from what we've seen from the initial enforcement activity. As I've said, old-fashioned coppering would be one. Fast action. If we look at Axiom Ince, they decide to investigate in only in September, and they've progressed to dawn raids and arrests in November, which for a biggish beast like the SFO is a pretty quick turnaround, I think, from inception to action. And as some other the comment has been made, they've gone from flash to bang quite quickly. As I said, raids, an effort to deal with the long-standing recruitment issues that the SFO have had. He said he wants 150 new staff in post. That's going to take the agency to 600. Apparently, they've already issued 100 job offers to fill those vacancies. The question was asked last time around about data. I think there are moves there to look at sweating data. I did ask if they were prepared to make a public comment on the use of things like data analytics. Haven't heard back yet, but it's clear that data is part of this. F. Grave is a physicist by background and is obviously more into data and maths and sciencey type stuff than some of his predecessors. And I guess it also comes timing wise at a good time, because these section 2 powers that I've talked about are also being extended as well. So there's more powers to deal with things like fraud and failure to prevent, etc. So as I said, early days, but it seems that he's something of a breath of fresh air at the SFO. Obviously, dawn raids in themselves aren't sufficient. He's got to get the convictions, and that's where some previous directors have failed, that they've been good at the start of investigation and let down by procedural failings when it's come to trial. So we won't be able to judge these things fully, I guess, for another 3-4 years by the time these cases have come to court. But as I said, a promising start.
Matt, do you have a question or comment for Jonathan?
Jonathan, I just have a quick question. You had mentioned that the director managed to get 80 people roused in the morning. So my question is, was this dawn raid actually at dawn? Because you have rained on my parade before, telling me the hard truth that some dawn raids happen in the middle of the day and they actually schedule them in their advance. They're not even raids. So what's going on?
I believe this was a genuine dawn raid.
Excellent.
One of the best comments, it's probably lost on you, but there was a UK politician called Derek Hatton back in the day. Are you aware of the work of Derek Hatton?
No.
So Derek Hatton he ran Liverpool for a while, and he's an old-fashioned politician. I mean that not in necessarily the nice sense of the word, but he's also one of the. I went to an after dinner speaker thing where he spoke. He's one of the funniest people I've ever heard, and he was charged with corruption for his time in office, and he had two great lines, I think. One was he said that he'd had a dream that he was at the pearly gates and there were a set of clocks and the clocks were moving backwards. And he said to St. Peter, "What are these clocks doing?" And they said, "Well, every time a politician makes a mistake, the clock goes back 5 seconds." And he says, "But where's my clock?" And he says, St. Peter said, "It's in the kitchen. We use it as a fan." And and his other great line about the corruption investigation is he said, "The police never ever found anything in my house. They did dawn raids, but they made a really simple mistake. Their dawn raids were at 7 a.m. Dawn in my house is 6 a.m.
Well, I am thrilled that dawn raids are back at the proper hour.
Yeah, exactly.
So, Jonathan, I've been following the new director via the press, and now with your comments, it seems like, number one, he's really a breath of fresh air and what the SFO needed, but two, that he's setting building blocks that will allow perhaps more in-depth, sophisticated, or ongoing investigations down the road. Do you get that sense as well on either of those points?
I do, yeah. And he's obviously done work in police leadership as well as being a chief constable. There's a body that sort of looks after leadership across police forces, and he's had roles there. And I think one of the issues that the SFO probably have had in the past is it's hard for prosecutors these days to get all of their ducks in a row all the time. And there's a temptation from some to say, we are the law, we'll do what we like. And you see that, you know, prosecutors in all countries, in all areas. And I think that seems to have been one of the failings. You oughtn't to need to be told that you should not go and meet somebody in the back room of a pub and get a set of documents and agree that it's completely off the record. You ought not to be told not to take calls from lawyers, from people allegedly representing suspects in investigations as a director, to pass on a message that if X and Y plead guilty, then there'll be better results all round, and to put pressure on one set of defendants on behalf of another. So there have been failings, I think, at the agency. You get back, don't you, to you might have it there, we have it here. Justice must not only be done, but it must be seen to be done. And prosecutors are judged usually to a higher standard than the defense. And if he can get those building blocks right, as you say, of do the basics, make sure that you're collecting the evidence in the right way, make sure that you're conducting interviews correctly, make sure that you're doing the investigations. And of course, you can't outsource that to the corporations, lawyers to do the investigation for you if you're wanting to hit individuals within those corporations eventually. So hopefully some of those messages are getting across. And if that is the case, then I think that some of these convictions or some of these cases will lead to convictions that stick.
All right. We're going to go not only across the Atlantic, but across the United States to the West Coast to Jay Rosen, E&C and monitoring consultant. Jay, you have been taking a deep dive into the SAP Foreign Corrupt Practices Act enforcement action. What are some of the things that really struck you about this enforcement action?
Thanks, Tom. The year in FCPA enforcement started off with a bang on January 10th with the announcement of a resolution of the outstanding SAP enforcement action. The bribery schemes used by SAP were massive in scope and literally worldwide in geographic area. SAP SE agreed to pay the Department of Justice and the SEC approximately $222 million in penalties and disgorgement. SAP also entered into a 3-year deferred prosecution agreement with the Department of Justice, imposing a $118.8 million criminal penalty and administrative forfeiture of $103.4 million. The FCC order found that SAP violated the FCPA by employing third-party intermediaries and consultants from at least December 2014 through January 2022 to pay bribes to government officials and to obtain business with public sector customers in 7 countries: South Africa, Malawi, Kenya, Tanzania, Ghana, Indonesia, and Azerbaijan. Given SAP's prior SAP enforcement history, its recidivist practice, FCPA status, its culture of non-compliance, and non-prosecution agreement from 2021 with the DOJ's National Security Division, as well as administrative agreements with the Departments of Commerce and Treasury relating to export law violations. One might wonder how SAP was able to receive such a superior result. SAP used third parties monikered as business development partners, BDPs, which were eligible to earn commissions for SAP sales on which they assisted. The bribery schemes are so pedestrian, yet they permeated the company from 2014 to 2022. The very pedestrian nature serves not only as a warning for companies and compliance professionals, but also a roadmap for compliance program monitoring, improvement, and remediation. First off, in South Africa, in the bribery schemes, payments were made for non-existent work or services billed by corrupt agents. In Indonesia, intermediaries used fake training invoices to issue payments that were created slush funds to pay bribes. Sound familiar? Employees at Indonesia intermediaries created shell companies to generate these false expenses. And finally, in Azerbaijan, lastly, a middle-level SAP employee provided improper gifts in December 2021 and January 2022 to multiple officials in an effort to close business. SAP entered into a 3-year deferred prosecution agreement with the Department of Justice. Given the multi-year range from 2014 to 2022, various bribery and corruption schemes worldwide geographic scope, the amounts paid in bribes and benefits garnered by SAP from their corruption, one might charitably wonder how the company was able to reap such a positive outcome of only a fine and a penalty. Well, we'll take a look a little bit closer. The starting point for this analysis is the DOJ and their deferred prosecution agreement. The first key point to note is that there is no self-disclosure by SAP. As the DPA noted, SAP only began to cooperate after investigative reports were made public in South Africa in 2017. The DPA noted that SAP immediately began to cooperate after the South African reports were made public and the South African related misconduct of 2017. This provided regular, prompt, and detailed updates to the fraud section. The cooperation included producing relevant documents and other information to the fraud section from multiple foreign countries expeditiously while navigating foreign data privacy and related laws. The company promptly collected, analyzed, and organized voluminous information, including complex financial info. It translated voluminous foreign language documents to facilitate and expedite and view the fraud section office. Here's the remediation. The DPA reported extensive remediation by the company as well as information provided in the DPA and is instructive for every compliance professional. The DPA noted that SAP engaged in some of the following steps. 1, they conducted a root cause analysis of underlying conduct. They, 2, conducted a gap analysis of internal controls. 3, they took a comprehensive risk assessment focusing on high-risk areas. 4, documented use of comprehensive operational and compliance data. 5, significantly increase the budget, resources, and expertise devoted to compliance. 6, enhance its code of conduct and policies and procedures. 7, enhance its reporting of investigations and consequence management processes. 8, expanded its data analytic capabilities for over 150 countries, including all high-risk countries globally. And finally, they disciplined any and all employees who were involved in misconduct. Obviously, SAP engaged in a wide range of remedial actions. It all started with the root cause analysis. Root cause analysis was enshrined in the FCPA Resource Guide 2nd edition as one of the hallmarks of an effective compliance program. It stated the truest measure of an effective compliance program is how it responds to compliance or misconduct. Accordingly, for a compliance program to be truly effective, it would have a well-functioning and appropriately funded mechanism for the timely and thorough investigation of any allegations or suspicions of misconduct by its company, its employees, or agents. Sorry about that. Equally of interest are the references to data analytics and data-driven compliance. SAP not only did so around its third-party program, but also expanded its data analytic capabilities to cover over 150 countries, including all high-risk countries globally. The SEC order also noted that SAP had implemented data analytics to review high-risk translations. The DPA follows the Abermale FCPA settlement by noting again that data analytics is now used by SAP to measure the program's effectiveness. This language follows a long line of DOJ pronouncements, starting with the 2020 update to the evaluation of corporate compliance programs about corporate compliance functions or access to all company data. This is the second time it's been called out in a settlement agreement in this manner. Additionally, it appears that by using data analytics, SAP was able to satisfy the DOJ's requirement for implementing controls and then effectively testing these controls throughout the pendency of the investigation. Finally, the DOJ noted that SAP had enhanced and had committed to continuing to enhance its compliance program and internal controls, including ensuring that its compliance program satisfied the minimum elements set forth in Attachment C of the DPA. Based on all these factors, SAP's remediation and the state of its compliance program, the company's agreement to report to the Fraud Section Office set forth Attachment D to this agreement. The DOJ determined that an independence monitor was unnecessary. And after this little bit, Matt will give his thoughts on that. All in all, this seems to be an outstanding result for SAP, which the company and its compliance team should take great credit in going forward. The DOJ is clearly sending the message that self-disclosure is the most important thing a company can do in any FCPA investigation or enforcement action. So to leave you with this, the DOJ's message could not be any more clearer. Self-disclose, self-disclose, self-disclose.
Jay, how do you assess the, and I know you talked about it a little bit, but we had some really incredibly bad facts. So it's the message here that you can make a comeback if you follow these prescriptions that you've laid out that the DOJ has told us about.
I don't think this is just recent now. I think we've seen it the last 2 to 3 years. So I believe that one of the significant areas that I spoke about here was data analytics, and it's not going away. We're still in the month of January, and we've had 2 big FCPA matters announced, and preferential treatment was given to those companies that use data-driven analytics. So I think not only is it if you've got the bad facts, but if you have good data, they can somehow balance each other out.
All right. Well, Matt, I think Jay has set you up a little bit. You wanted to visit, I think, a little bit about SAP, but also eBay. What do you got for us?
Yeah, so I have a bonkers case with involving eBay that happened the day after the SAP resolution was announced. The U.S. attorney in Boston announced this settlement of a criminal case against eBay, and SAP and eBay taken together leave me somewhat confused about when we do and don't get compliance monitors in various cases. So let's lay out the eBay case and what this was about. Some of you may already have remembered this. This was back in 2019. This happened. The news broke of it in 2020 when 7 internal security employees at eBay basically stalked and harassed an online critic of eBay, a woman named Ina Steiner, who ran an e-commerce news website with her husband, David. The security employees stalked the Steiners at their home in suburban Boston, checked them out, went, visited, stood outside their property, put a GPS monitor on their car, began to harass them by doing things such as delivery of live insects and spiders and snakes, things like that, to their home, would post ads online about sex parties that were going to be happening at the house, which I presume were fictitious. And then they did other things like very disturbing stuff, sending a book about how to prevail through the death of a spouse. They sent that book to the Steiners household and stalked them, terrorized them, harassed them at the behest of eBay's then chief executive officer and then chief communications officer. And these two guys, they had been just stewing about the Steiners' unflattering coverage all through 2019. Finally, they were saying something to the effect of, we have to, bury the Steiners now. I think, they were talking about harassment. I don't think they actually meant physical violence, although I'm not sure. But ultimately, the CEO directed the communications officer, said, I really want the Steiners to go away once and for all. The communications guy then says, we're on it. He directs the security people to start this harassment campaign. And then in the midst of that, in September of 2019, and that's an important detail, the CEO at the time, David Wenig, he leaves the company. eBay had not been doing well anyways, so I think that the board just decided it's time to pull the plug on the Wenig tenure. Ultimately, the communications officer also got fired. And then these cases come out. And then the security guys, I think they were all men, maybe 1 or 2 women, they were all indicted by the feds. They all wound up serving prison sentences. They're all convicted, all 7 of them. The then CEO Wenig and the chief communications officer have not been criminally charged in all this. But then fast forward to finally last week, eBay has a corporate settlement related to all of this, wackadoo nonsense that went on. They wound up paying a $3 million criminal penalty, which doesn't sound like much, but it was the maximum possible penalty allowed under the statute for that sort of violation. And then they got a compliance monitor. Oddly enough, and I don't want to go down this rabbit hole, but they did not have the CCO certification requirement that SAP and so many others did. eBay didn't get that for eBay's case, but they did get a monitor. So how come eBay gets a monitor, but SAP doesn't? And I was confused by this because if you go back to eBay, to SAP, and what really happened with SAP, if you look at the SEC's settlement with SAP, they talk about there was a failure of entity level controls at the company, which broadly speaking means corporate headquarters drafted a really good looking set of FCPA policies and procedures and couldn't get the subsidiary business units to actually follow those things. The subsidiaries disregarded all of that. They engaged in their nonsense, and that was the FCPA violation at SAP. Well, so you can remediate away from that and get away with not having a monitor, but eBay can have a very specific, bizarre incident that happened 5 years ago now, and then get rid of everybody involved, but you do get a compliance monitor for that. this does not add up in my book. And so I went back to the Justice Department guidelines on when they select a monitor, and there are 10 questions, and I started looking through. But I will give you an example of some of these questions that leave me puzzled. So question number 8 from the Justice Department is whether at the time of resolution, the company's risk profile has substantially changed, such that the risk of recurrence of the misconduct is minimal or non-existent. Well, SAP was selling software when they had their FCPA violation. They are still today selling software. They are still, working through subsidiaries. They did change the sales commission structure for intermediaries, and I suppose that's one prophylactic measure you can take. But by and large, that was SAP's second FCPA violation. It was their second criminal issue in 3 years because they had that trade sanctions thing that happened in 2021. So I could make an argument that at the time of resolution today, their risk profile really hasn't changed that much for a recurrence of FCPA violations. Maybe somebody else in a different jurisdiction could do it somehow. Maybe they haven't successfully managed to impose entity level controls. It looks to me like SAP has worked hard and they have made great strides to prevent it. But you could make an argument that maybe this still needs some work. Contrast that with eBay. Now, the CEO who wanted this, gone. The chief marketing officer who was in charge of putting this into operation, fired. Then got another job, that got publicized, he got fired again. The 7 people who actually terrorized the 2 website owners, all of them in prison. So that's a pretty structural change that I don't think a new CEO is going to say, why don't we start sending spiders and creepy books and bloody pig masks and orgy invitations to the critics that we don't like. I don't see this as a recurrent behavior for eBay. And yet they still have the monitor. And that's just one question that they have, but I'll give you one more as an example. Question 4, whether the underlying criminal conduct was longstanding or pervasive across the business organization, or was approved, facilitated, or ignored by senior management. Well, was the underlying criminal conduct long-lasting or pervasive across SAP? Yes, it lasted for years, and it was in the 2010s. SAP is a big company. The 2010s for a big company is not the FCPA Stone Age. They knew full well that they had FCPA violations and risk because they had one before. They settled it in 2016. So that's a yes on SAP, but they don't get a monitor. Or was that misconduct approved, facilitated, or ignored by senior management? Now back over to eBay. Yes, it was approved by management. The CEO said, I would love the Steiners to go through hell. And the chief marketing officer said, we are on it. And then they went and they did it. So I do see why eBay got its compliance monitor. I don't necessarily see why SAP didn't get its monitor, or more broadly, I don't get how you can have one and the other in the same universe at the same time. I am confused. If anybody else out there has any thoughts on the application of monitors, I'd love to hear it, but it's just a fascinating look at what are we doing here? And it seems just a bit indecipherable or arbitrary or capricious what the Justice Department is doing.
Karen, do you have a question or comment for Matt?
Yeah, Matt's sort of final comments were the aim of my question, which is, I tell me if you disagree, but I was sort of seeing that the addition of the monitor, or the threat of the monitor maybe, is just one of the many sort of tools in the toolkit that the DOJ might toss out there. And that from that point forward, it's just one big negotiation and you're moving sort of chess pieces around to get everyone happy. So it doesn't feel as formulaic. And I also, this is a question for you actually more than otherwise, but in practicality, I don't know that we see these things in this entirely separate as a all right, fine, lowered, and monitor. I think all these things are in conjunction, or sort of levers that they're pulling throughout the sort of settlement negotiation discussion. So I guess that was my question for you. Do you think there are lawyers in there monitor is actually the best way out of this? I'm just curious of how you think this in practicality, how do we get to this place?
I suspect that there was a lot of negotiating on the eBay case that it was clear when you read the U.S. attorney's settlement and the press release with this. And of course, this is a U.S. attorney who I am sure, like all U.S. attorneys, has dreams of being elected a senator or a governor or something like that someday down the road. So you make big, broad points. But it was very clear from the settlement with eBay, they were really upset with eBay. And they were particularly upset with how eBay styled and framed the departure of its then CEO in 2019, where they said, we just had a mutual agreement that this wasn't working out. And then behind the scenes, really, it looks like, that CEO was a terrible person. He was behaving like a jerk to the Steiners. And then he walked away with a $40 million severance package. And the Justice Department, the U.S. attorney here in Boston, he talked at length about that in the settlements. So I think they were really just upset that we could only nail these guys for $3 million. That's the maximum in the statute. I get the sense that if the maximum was 20 million, they would have had a 20 million fine. So what else could a Justice Department prosecutor do to make a company really feel the pain if the statute doesn't let you deliver the pain? Monitor is a great way to deliver pain. They're very expensive, and they're kind of a drag to have around. So maybe that was why. But if in theory, in best practice land, a monitor is there to make sure that you can really change the culture the way that you need to and the way that you're promising, SAP has a much more expansive need to change its culture. The culture problem at eBay was really terrible, but very confined to a few number of people, all of whom have now moved on. Funny enough that the Steiners, the victims in this case, they are very upset that no criminal charges have been brought against the former CEO, and they are still pursuing a civil case in federal court against the CEO, and that's just recently been authorized to move forward. But back to what can a prosecutor do to really turn the screw and make a company feel it? I don't know that they had enough ability with eBay, and so therefore the monitor became a very nifty device to ratchet up that pain. But that's not what a monitor is supposed to be about. A monitor is supposed to be about helping the company change, and SAP has a much more expansive need for change, not eBay. So I'm just puzzled by all of this.
Karen Woody, we had a really interesting decision out of Delaware Chancery Court interpreting the McDonald's decision around duty of oversight of corporate officers. What did you find interesting in that case?
Sure. All right. So you're right, Tom. It's now been about a month since Vice Chancellor Will in Delaware issued or dismissed a complaint against the president of Segway, the two-wheeled device manufacturer. And the complaint alleged a breach of fiduciary duty. But more particularly, it dealt with the fact that the plaintiffs were alleging that the president of Segway had given inaccurate financial data numbers to Ninebot, which is the company that acquired Segway in 2015. So obviously, if you think through, when a president is giving numbers to the potential merger partner, and maybe those numbers are incorrect, there's problems there. But I think to really dive into this case, you have to go through a little of the background. And I want to talk a little bit about McDonald's, which this case really is trying to, as you say, interpret. So first, let's back all the way up. There are two major fiduciary duties that directors and officers have to take into account, or to exercise those duties, I should say. That's the duty of care and the duty of loyalty. Duty of care requires that fiduciaries effectively inform themselves about material information, workings of the company before making a business decision. And they also need to take care to sort of be prudent in the exercise of their duties. Conversely, the duty of loyalty requires exactly that, sort of no conflict of interest, undivided interest toward the corporation rather than personal interests, no self-dealing, that kind of idea. So inherent in sort of these are the two primary fiduciary duties. There's also the duty of oversight, which really derives from the Caremark case in 1996 that we've spoken at length about on this podcast and elsewhere. But effectively, after the 1996 decision in Caremark, you have this, I don't know if we'd say new duty of oversight. There's an interpretation that the duty of loyalty includes this duty of oversight. And so when it's housed essentially under the duty of loyalty, it means that you have to not act in bad faith. So what this means is duty of oversight means you have to have some sort of system of information, reporting systems, compliance programs that effectively inform senior management and the board about any sort of potential issues within the company. And should there be certain information from those systems that is delivered to the board has to take that seriously. So what that means is there are really two ways to bring a Caremark duty of oversight claim. Two prongs, as it's been called in the cases. A systems or information prong one claim, which says you basically didn't set up one of these systems that should catch these things, and or you just didn't monitor it. So you set it up, it's a paper program only. No one's actually checking the output. The other one is the red flag prong, or the other way to bring these claims is, and that is, some things are going wrong. There is some misconduct. There are these proverbial red flags, and that you acted in bad faith by consciously ignoring those or disregarding those red flags. So in the bad faith thing is no joke. I mean, it's a really high bar to clear. And in fact, Caremark is a very hard, the Caremark standard is really hard to meet. So almost all these cases are tossed on a motion to dismiss. In the last few years, we've seen a handful get past the motion to dismiss stage, usually because of these egregious facts, like the Boeing case, the Bluebell ice cream case, sort of terrible outcomes, terrible facts. Those cases up until last year all had to do with the board of directors and the oversight that the board of directors was giving. There had not been a case until a year ago against an officer sort of performing the duties of the job. That changed last year in January 2023, when Vice Chancellor Laster allowed, or basically said that the plaintiffs cleared the motion to dismiss case in the motion to dismiss standard in the McDonald's case. McDonald's was this sort of terrible, again, set of facts, pervasive sexual harassment, employment claims made by women at McDonald's, and they brought the lawsuit against the executive vice president and basically HR. I think his title was something goofy like people officer or something, for sexual harassment claims, and sort of, again, both the monitoring and sort of oversight of this terrible culture, and then also claims again about sexual harassment that he himself had performed, that he was accused of. So they brought that lawsuit as a Caremark claim, as sort of, you have breached your duty of oversight. His argument, or his defense, was, no, that just applies to the board. It doesn't apply to officers. And Vice Chancellor Laster just made him eat that and then said, absolutely not. This is, again, an egregious case. There's clearly red flags. There are clearly red flags here. There's enough here that the plaintiffs have said that survives the motion to dismiss, because he said, I see a lot of facts here that support the inference that this guy at least knew of evidence of his own, of corporate misconduct, and then also had performed some of this misconduct himself. And so he said, there's enough here to sort of indicate action done in bad faith. And this was a pretty huge deal. And we talked about this about a year ago on this podcast, because it was such a huge deal when this came out. So, and I have to say, even Laster said the fact that he had been accused of sexual harassment himself was in itself a breach of fiduciary duty. So a violation of his role toward the company by his own bad act. So it was a pretty sweeping, it could have some really significant implications on the McDonald's case a year ago. So fast forward till now, we have the Segway case that came out about a month ago. Same idea. The plaintiffs are bringing a lawsuit against the president of Segway for this accounting issue. Then I have to say, Vice Chancellor Will, a year later after McDonald's, seems to push back heavily against the direction I think Laster was going. She basically, I think the tide has shifted here, because she very much says, listen, bad faith has to really be bad faith. There's a reason it was sort of called the citadel of Caremark. I mean, these are really high bars to clear. And so she says there's no different standard for officers versus directors. McDonald's, as it applies to officers, didn't lower the bar for officers vis-a-vis directors. She says it's the same bar. It's still Caremark. It's significantly high, and there has to be proof of bad faith. So the point is, like, inaccurate financials related to potential revenue decreases or issues with customers, those are not inherently red flags that would rise to the Caremark claim, because we're really in like at least sort of a gross negligence standard for this. And Vice Chancellor Will's like, I don't see it. I don't see that there's enough here for that. So the takeaway is we've had this now interpretation of McDonald's, which seemed like I don't know if we'd say an outlier, but very much a push toward a pro-plaintiff, really holding directors and officers now liable for their actions and their lack of oversight. And it seems like the pendulum swung a little bit back after the Segway case last month. There's been a retraction to a like, hey, we were serious when we wrote Caremark a while ago. There's only been a handful of claims that have even gotten over a motion to dismiss case on Caremark. And even though those were about directors, McDonald's was this kind of crazy outlier that we're not moving in that direction any further. We sort of, if anything, I think, retrenched back to the high bar of Caremark claims. So that's where we are.
So Karen, you follow the Delaware courts for many years, and it strikes me that we actually see this sort of, I don't want to say dialogue, but it took Caremark almost 20 years to sort of have an explosion of growth in some of the cases you named, Boeing or Bluebell Ice Cream, some of the others we've talked about from time to time. Isn't McDonald's leading to Segway part of an internal court dialogue around a new doctrine that you may see pushback, retrenchment, and then move forward?
Yeah, I think that's fair. I think there is some pushback. I mean, we saw, as you know, Tom, we talked about a lot, the sort of slow march of weakening of Caremark from Bluebell all the way to Boeing. There's 5 or 6 cases in there where, you know, these claims survived a motion to dismiss. I would argue that in nearly every one of those cases, as we talk about all the time, those facts were terrible. I mean, the Boeing facts are terrible. Bluebell Ice Cream, people are dying because there isn't someone, you know, with their finger on the pulse here or you know, asleep at the switch kind of thing. So I do think the facts here don't feel as egregious, and not to suggest that law is always that malleable, but I think, you know, we all live in the world and the context matters. The other thing I will say, and that I do think was a link between all of the cases that had been successful over the motion to dismiss, McDonald's included, is that they were piggybacking on a regulatory enforcement action. So even McDonald's had an EEOC claim underneath it. So all of these were plaintiffs were able to, for a couple of things, were able to get more discovery because of what was made public through a regulatory enforcement action. And also, I think the fact of the idea that you've already screwed up, you've violated FAA regs, you've violated FDA regs, that already is moving the momentum toward something's pretty wrong here. So this one doesn't seem, at least from what I could understand, have some sort of clear violation that predicated this additional plaintiff's class action. It was just sort of we lost some money, business went down. And in fact, Vice Chancellor Will points it out. She goes back to it listen, these are business people and not every business decision is going to go well. So you can't just keep suing people in their personal capacity because of that. There's some deference to business decisions. And I think they very much wanted to hold to that foundational understanding of, this idea of the business judgment rule. So.
All right. Well, we are now on to fan favorites, shout outs, and rants. We're going to go back to Mr. Armstrong, then across the pond to Mr. Kelly, Professor Woody, Jay Rosen, and I'll bat fifth. Jonathan Armstrong, do you have a shout out and or rant for us?
I have a shout out, and I have to say from the start, I would like to repeat last time around's shout out every time until somebody makes Mr. Rosen a job offer. But unlike every other US TV channel, we're not fueled by repeats here. So I've got something slightly original. I want to start a new little series of what I'm going to call popcorn cases. So cases that are coming up in the courts where you just better grab your bucket of popcorn and sit down for the ride. And this is the case of Nick Rossi. I don't know whether you've seen it over in the US. It's important to say, as I said at the start of the podcast, that anybody charged with a criminal offence is innocent until proven guilty. I want to stress that with Mr. Rossi. But he appeared in court a couple of days ago in Utah for a rape that was committed 15 years ago. Why are we getting around to crimes 15 years ago? Well, it appears that in Utah, there was at the time a 10-year, get this, 10-year backlog of DNA analysis for rape cases. I mean, that in itself seems to me to be pretty scandalous, that a victim of rape is waiting 10 years for the DNA analysis. But passing on that for now, it is alleged that in that 10-year period, Rossi fled. There was an international search for him, and it seemed that he had faked his own death. And the relatively lean, clean-shaven Mr. Rossi, it is alleged, then turned up as a somewhat corpulent, bearded man in Glasgow. So how did a somewhat corpulent, bearded man stick out in Glasgow, you might ask? Well, that was because he had somewhat unique tattoos on his arm. And Rossi was arrested. He'd gone into hospital as a COVID admission in 2021. The medical staff had recognized his tattoos, it seems, from an Interpol bulletin, and he was arrested. And the man arrested said he wasn't Rossi. And his case is that he is an Irishman who happened to be in Scotland for, I think, no established reason. And that somebody found him in the hospital and thought it would be a great way of pinning this conviction on him by, it seems, tattooing him whilst he slept. And he was also accused of operating under 16 different aliases. He says they are not aliases, they are typos. And his he says that his name, or he said at the time that his name was Arthur Knight. There was a somewhat unusual extradition hearing in Scotland. He was eventually extradited. And when he appeared in court via video link in Utah, he gave the name Arthur Knight Brown. So if your defense is that you don't run under aliases, it's slightly curious that you seem to have changed your name between extradition and appearance in the destination court. But it's definitely going to be a case to watch. He says he's disabled, he's unable to walk, he needs an oxygen mask, and there are some, let's just say, putting it neutrally, very interesting videos, if you search the internet, of interviews with news media, and a rather curious wife who assists him when he does various things on film. He refused in court to admit his name or date of birth and told the judge that this was, quote, complete hearsay. He also used an accent, I think last seen in the possession of Dick Van Dyke in Mary Poppins. And why he affected that type of English accent when he was somebody of loyal Irish provincial birth is, let's just say, as yet unclear. He was cut off by the judge in the middle of some submissions that seemed to be made for some reason in Victorian English. But this is definitely a case to watch. I think it's back in court, I believe, February the 1st. I will be there, popcorn at the ready, but that's one to watch, I think, for the year ahead.
Mr. Kelly, do you have a shout out and or rant for us?
I do. I have a shout out that is not at all compliance related at all, but I still think it's something that will brighten most people's day. This is about a band that recently came to my attention. I want to give a shout out to Saul Dreier and the Holocaust Survivors Band. which I read about in the news. I think it was last week. So Mr. Dreier is 98, originally from Poland, and survived the Krakow-Pazlau concentration camp in World War II. And since then, he formed a band with other Holocaust survivors who go around playing gigs. They, I guess, play klezmer music, and he has played all around the world, and he is still doing it at 98 years old. As a fellow drummer myself, I did not have anywhere near as successful a career as Mr. Dreier did. I just want to give a shout out to this guy. I mean, this is amazing that, this is 80 years ago. He suffered immeasurable pain getting through the concentration camps, and he turned right around and owned that pain and has turned this into a wonderful testimonial for everything that everybody else suffered there. And yet again, year after year, you find still to this day Holocaust survivors who have done amazing things with their lives. And shout out then to Mr. Dreier, who's still keeping it real at 98 years old. And that's all I got.
Let me just add that he also recently played at the White House. Professor Woody, do you have a shout out and or rant for us?
I have a very quick shout out. I find myself in Indiana this week, where it has been a high of -5 at times. So I have a shout out to good friends and good people here in Indiana who run the homeless shelters here, including the Nest and Beacon, because they really are doing life-saving work. It's just really unbearable. Secondly, my pipes have frozen here, so I give a shout out to all the plumbers in the area who are working overtime. So yeah, I just as a word of caution, Armstrong, I would not maybe recommend traveling to this area of the United States anytime soon. It's not ideal, but I'm sure for those in Boston, this is just like a usual Friday.
Par for the course.
Jay Rosen.
So you may not be aware of this rave that I'm going to give right now, but we are now in Cara season. And you might ask, what is Cara? Cara is a type of navel orange that was first discovered in 1976 at the Cara resort in Venezuela. And they are now grown in Florida. The season that they're in season goes from January until April. And if you have a Trader Joe's near you, they're in the fruit section. But basically, they taste like navel oranges, but the flesh, instead of being orange, is pink like a grapefruit. So I've been pining for the last 8 months for these guys to come back in season. So you all have an assignment. Jonathan, I don't know if your market carries the Cara, but if everyone can check it out and see if you like the Cara navel orange, I'd love to have you on the bandwagon. So thanks.
Are you sponsored today, Jay? This message comes to you from the Cara Marketing Corporation.
So I'm going to give a shout out to Elton John. Elton John was awarded a 2024 Emmy. That gives him the coveted title of EGOT, which is those who have won an Emmy, a Grammy, an Oscar, and a Tony. There are 18 people who've done it, and Sir Elton is now one of them. So shout out to Elton John. I remember way back when. Keep cranking them out. Well, ladies and gentlemen, I know we have some people with top of the hour sign off, so we're going to sign off. Thanks, everybody, for joining us, and can't wait till next time.
Thanks, Tom.
Thanks again, Tom.
Hello, everyone. This is Tom Fox. Thank you for listening to this episode of the award-winning Everything Compliance. If you've enjoyed this episode, I hope you'll subscribe, rate, and review wherever great podcasts are listened to. Everything Compliance is a special production of the Compliance Podcast Network.